y'all, I'm not gonna go through it. Jackson's is this year. Who wants to go to Jeremy Dodge?
Agreed.
This is
What else am I gonna? I don't have another honeymoon coming up.
yeah. And it's the perfect time to get someone to take care of it. A protest against the you don't have to go out. Yeah. Everybody knows.
All rise. The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Yes, oh yes, oh yes. The Supreme Court of North Carolina has resumed sitting to the dispatch of business. God save the state and this honorable court.
Good afternoon. Our next case is Mauck versus Cherry Oil Company et al. And we will hear from the, let me note that Justice Riggs is recused. We'll hear from the appellant.
May it please the court. Chief Justice and Associate Justices, my name is Walt Tippett, and I represent appellants Louise and Armistead Mauck. I would like to reserve 5 minutes for rebuttal. This case is about control of a family business that was formed almost 100 years ago. My client, Louise Mauck, is the sister of defendant Jay Cherry. He is 13 years older. Their grandfather formed Cherry Oil in 1928. We are here through a direct appeal to this court to correct the business court's errors. We're also here because the business court committed what we would characterize as judicial overreach. Very broadly, I would like to first describe what we think that overreach was, then very briefly set the stage what we think are just a few minutes of essential facts and legal issues, and then finally go through the argument as we think is necessary to understand the briefs in a more concise way. So, in regard to how we consider the business court's errors, first, the business court denied the Maucks access to these courts first by declaring that that my clients had no standing to ask for dissolution, in direct contradiction to the Supreme Court's holdings in Meiselman and its progeny for the last 40 years or so. Then, once it started considering claims under a motion to dismiss analysis under 12b-6, it wrongly applied procedural rules and substantive law. Then, later in the case, on the two claims that survived the motion to dismiss, it wrongly applied other law for under summary judgment. So, at the end of the day, after first using a shareholder agreement to deny my clients access to the court, it then threw out the claims my clients had espoused under the same shareholder agreement to give them any substantive relief thereof at all. Therefore, at the end of the day, my clients have been denied any access whatsoever. So, we will characterize in our arguments this afternoon, just barely, the Maucks have been denied their day in court. Its doors were closed to them. The decisions appealed from do not reflect the proper role of the business court. The Maucks are entitled to start over, and we ask this court to reverse the business court's decisions.
So let me stop you and ask you about the one thing you just said about the starting over. So if you had a scenario where a trial court said, I'm looking at your claims and you just have not stated a claim on which relief could be granted. I'm dismissing for lack of standing. And then there was an appeal. Does the appellate court say you're wrong, you didn't understand standing law, go back, start over? Or do we say, well, that's a question of law. Whether you stated a claim under Rule 12b-6 is a question of law. So, there's no reason to send something back when it's a question of law. We'll just look at it and say the court could have just said, I'm dismissing you on 12b-6, not standing, affirmed. Where are we in this, in your view? Do we, on the standing question, do we just decide whether it's right or wrong and send it back? Or can we continue to look at it if there were other reasons that ruling should be affirmed?
Certainly, sir. The standing issue only applies to one of the claims, and that is for the dissolution claim. So as to that particular one, I think that was simply incorrect, and I think that claim should be entirely reinstated. So,
but I think the argument you're hearing from a friend is the reason that the court got the standing argument wrong was it was actually doing a different analysis about whether or not there's any chance for you to prevail, and it kind of crammed that into redressability. But that's a legal question, so we can just look at it and answer the question. We don't need to send that back. What's your view on
that? Justice Dietz, I want to make sure I'm responsive to your question, and so I'm going to answer what I think you're asking. I think no matter how the court may look at the business court's decision, it certainly got it wrong on the standing issue, because what it did completely departs from what Meiselman and its progeny allows. Certainly there is, the court disregarded what we would call the greater view that it should have adopted. If Your Honor is asking whether, okay, maybe you're right, Mr. Tippett, but beyond that, maybe there's some other grounds, we would also disagree with that as well, that even if you looked at a greater view, we also contest that, but the business court didn't even get that far. And truly, Your Honor, I don't mean to be unresponsive. Is that responsive to your question?
Yeah, absolutely. I just think, so let me be a little more specific. So I understood part of the trial court's reasoning to be that you can't meet the redressability prong of what we've sort of articulated as our prudential standing doctrine that's taken a lot from the case of controversy requirement in federal courts. Mm-hmm. Do you agree with that?
I agree with that legal premise, sir.
And if the court was thinking, well, this is a redressability problem for standing, but what it really was just that you're not, on the facts that have been alleged here, you haven't stated a claim in which you could entitled relief. In other words, the court there would be no availability of dissolution on the facts alleged, that we could affirm, because it's just, those are both legal questions, and we should try to affirm on any ground that would permit us to uphold the lower court ruling. That's what I'm trying to figure out. And I know you're going to disagree with that latter point, and we can talk about that. I'm just saying to you, where are you on that view?
Well, certainly I think there is also, and if that's the second prong, I'm certainly prepared to address that whenever this court would like me to address it. I don't mean to be unresponsive, but I'll go ahead and address it now. We certainly draw a very real distinction between what the statute contemplates and what the shareholder agreement contemplates. The shareholder agreement has two very real distinctive differences between what it would allow the superior court to award to my clients in terms of dissolution. Very simply stated, sir, the process of valuing the shares is different. And then what I think is incredibly different is Section 7 of the shareholder agreement talks about the terms. One is colloquially described as price. Price is set differently, but what I think is most remarkably different is an entire section about terms, basically seller financing and when my clients might get paid, if ever, under the shareholder agreement. And so that's the second prong, Justice Dietz, that we think is most remarkably different. That setting aside the first issue is was the law followed, and we would say respectfully, no, it wasn't. Meiselman was disregarded, and then redressability issue we think is very different, of course, because of Section 7, the terms issue, as well as we think the prices are derived differently as well. And again, Justice Dietz, I don't mean to be unresponsive. If that is responsive, I will return.
Yeah, you've answered my question. I'm just trying to see if you would agree that if we think the standing ruling is wrong, we could move on and say, but was the court's reasoning for a ruling on standing actually applicable to some other basis to dismiss, and then say, well, we're required to just uphold it on that alternative basis. That was what I was.
Sure. And we would respectfully say that, of course, as Your Honor acknowledged, we would say, even if you get past the standing issue, there's all kinds of other issues that still should provide my clients relief under the shareholder agreement that should have been acknowledged. Back again, their shareholder agreement claim for breach was dismissed improvidently, we believe as well. Okay. Returning to the argument, if I've been responsive enough.
Yeah.
Okay, first, so again, as I was concluding, we asked to return to the trial court for a do-over because almost systematically, we got unfair treatment on standing, we got unfair treatment on a motion to dismiss, and then ultimately, in an extraordinary ruling, the business court decided that on balance, we should lose at summary judgment. And as I'm sure this court is aware, there is no balancing test at summary judgment. If there's any evidence at all, my client's claim should have survived summary judgment. And that is not what the business court ruled. So we believe that the arguments should prevail and we should get our chance to be in court. We should not be denied access, that the business court simply got it wrong and we should get our chance to go back. So here are just a few minutes of facts and context. First, setting aside the fact the company is almost 100 years old, my client's direct involvement is almost 30 years old. Armistead Mauck, who married Louise long ago, left banking to join this company in 1995. The company was in trouble. These are all matters of record. It thrived during his participation. One of the express agreements is that as an inducement for him to leave his other career, he would be treated as an equal. Generally speaking, they were. As the company grew, it acquired affiliates. The core business, Cherry Oil, there was always a disparity in ownership. The Cherries, which is Louise's brother Jay and his wife Ann, owned roughly 2/3. The Maucks owned roughly 1/3. Setting that aside, all of the new acquisitions and all the ancillary businesses were owned 50-50. These are matters not in dispute. As they grew, that generally happened. Also true, management was 50-50. The titles were different, but the responsibilities were at least equal. My client would testify that honestly he did more than Jay. Jay's title was president. Armistead would testify that his direct responsibilities were greater. We're not going to resolve that today, certainly, but that generally worked for decades. Then the Cherries had a change of heart. The evidence in the record is that it had largely to do with estate planning and succession. That succession issue is at the core of this lawsuit in a couple of ways. First, it is certainly clear that was at least the inspiration for the Cherries' actions. It is also a question for this court whether that is sufficient as a matter of law to be a personal benefit. We'll come to that. In candor of the court, there are two facts that I must contend with. First, I've already mentioned that the Cherries own 2/3 of the stock. That is a fact. The second fact I must contend with is the Maucks, my clients, signed a shareholder agreement in 1998, approximately 23 years before the troubles most erupted. They were stewing a few years before then, but that is a fact we must deal with. That is when, in roughly the late 20-teens, the Cherries began a series of actions that culminated through their exercise of their voting rights and ultimately through their exercise of rights under the shareholder agreement. The Maucks shares were called and the Maucks employment was terminated and their roles on the board were terminated. Those were effectuated in a couple of ways. Primarily through the call of the shares, there is an unusual term by which as soon as the shares are called, literally the company exercises its rights to call, the voting rights are stripped. That happens before the stock is paid for. That's what the contract says. That as soon, that is clear. The voting rights are taken before the deal closes. That is problematic. That tees up the problem of the closing of the share purchase hasn't happened. That is not in the record. What is in the record, it hadn't happened by the time summary judgment happened. So that is the competing issue of, has there been breach? The business court concluded that my clients on balance were more responsible for the delay on balance. That is an improper standard. Where we're coming to you, though, is despite the two facts that I just mentioned, the lesser amount of stock and the signing of the shareholder agreement is mitigated substantially by the law of North Carolina, that unlike LLC agreements, which was a matter that y'all heard about earlier this morning, majority shareholders of corporations in North Carolina very clearly owe a fiduciary duty to minority shareholders. Very different than LLCs. In corporations, fiduciary duties are owed to minority shareholders. And the business court got that right. However, that narrow rule of law, where the contest in this lawsuit and where we respectfully contend the business court got it wrong as how that was applied. That's briefed carefully, and I'll argue about it more today to the extent we have time. The second element of law, which is very helpful to my client, is Meiselman. And Meiselman, which I'm sure this court deals with some regularity, is all about in small corporations that minority shareholders are entitled to their reasonable expectations. And broadly speaking, those reasonable expectations are defined not by documents. They're defined by an entire context. And from the beginning and the documents and throughout the relationship. And the business court concluded that a single snapshot, which is simply the shareholder agreement, was entirely definitive of the relationship and defined my client's reasonable expectations. And it did so in concluding that, and this is in record page 451, is sufficient to protect reasonable expectations of minority shareholders such as the Maucks. To be clear, what the business court did is a drastic, and I try not to be hyperbolic in any argument, but it is a pretty drastic departure from what this court and the Court of Appeals has ever held since Meiselman. So we underscore that we want this court to restore or preserve that which has been settled law of North Carolina, small, closely held corporations law, and give my clients a chance to protect those interests, which it invested, in essence, their lifelong career since 1995.
And Counselor, if I might get you to delve a little deeper, when I read the business court order, and I believe it's argued by your friends on the other side, it wasn't so much the whole of the shareholder agreement. It was specifically that this shareholder agreement has the put call option within it. And as a result of that, that would resolve any expectation or take care of any reasonable expectation. I believe circumscribed might have been the word that I read somewhere. What is your response to that?
Thank you, Justice Barringer. Our view of that is that that document counts for something. I'm not denying that it exists. I'm not denying that my client signed it. I'm saying that it cannot be read to be entirely dispositive, that under Royals and under Louder and under Meiselman, it must be viewed in the context of that which became before and during and the succeeding 23 years. And instead, the business court concluded that it is all that can be. And so I don't believe that's true, and that the court must have at least allowed some consideration of additional evidence, and it simply did not. And instead, it went so far as denied standing, which I think is remarkable, mindful of Justice Jeet's remark that perhaps this court can go beyond to look at other issues, and I don't want to speak to whether that's true, accurate or not, but my response, Justice Berenger, is that I don't agree respectfully with the business court because, again, if a person were to look at Royals and Louder and Meiselman side by side with paragraph, well, I didn't cite it in this particular note, it is remarkable departure from the narrow single shot of all the context where they say it cannot be looked at in a vacuum, and I would contend the business court looked at it absolutely in a vacuum.
Well, for informational purposes, if you do get another question about it, I believe it's section 11 of the agreement that I'm from which I'm referring.
Thank you, Your Honor. Thank you very much. Returning to that argument, the first issue we contend is that Armistead left his career. He invested that. Come 2021, the Cherries had a change of heart. They wanted to, in essence, have their legacy through their family. That was a departure, a contextual departure. Among the context that I believe is in the record is that many of these agreements were set up such that the Maucks and the Cherries would each beneficially retire, and they set up many of these entities to have a glide path for each of the families to these senior generations to go out in a certain way. The Cherries had a different view, such that it was. That's where we are now. We rely on the law that would have not allowed those facts to implement the way they did. So we come to you with that help. Our argument outline is basically the court had four substantive errors, the Meiselman issue, which we've already touched on at least twice. Next, the statute of limitations issue, which we think that the business court simply erred. We are very aware of this court's careful deliberation in Christenberry. We, however, don't think it applies because, unlike Christenberry, the DM Price contract was verbal and had no specific dates for performance. Christenberry was very different, where it was written, had an immediate monthly price requirement. This was none of that. And in contrary, it was also a closely held corporation with a course of performance and other issues. Justice, it's much closer to Pemby v. Pemby. We'll hit on that issues as much as we have time. Next, we respectfully contend that the business court did not apply correctly the business judgment rule because there are self-interested issues, so it does not apply. And finally, the personal benefit analysis was not used correctly in looking at constructive fraud. That comes back to this issue of succession. My friends seem to place a burden on us to suggest that there is only a monetary element in assessing personal benefit. That seems not to be the case, that we share that we have that burden. Personal benefit can be other than monetary, we contend, and certainly there is no requirement for that in North Carolina law. There are also procedural errors, which we talked about, taking away the reasonableness standard from the jury, not only in the statute of limitations issue, but also in looking at this issue of whether, sorry, I'm getting dry mouth. Excuse me, one moment. Talk a bit loud and fast.
Well, Counselor, since you've paused,
Yes, ma'am.
I'd like to pursue the business judgment rule point that you're making about self-interest. If I'm remembering correctly, the order took issue with that on two levels. One, I believe it had to do with the particularity with which it was pled, and then also, I believe the order stated that the facts that were pled fit more in a breach of contract rather than self-interest. Could you address that? And if I'm incorrect, correct me, because I'm going by memory, not my notes right now.
Certainly. I do think it may have hit some on the particularity issue. However, particularly in a constructive fraud issue, I don't think particularity is required. And on the personal benefit, because of the personal benefit, that's a key element of constructive fraud. And then on, I think that standard may have been heavy, and that's another remarkable thing that in paragraph 70 of the order, he challenges, he applies the wrong standard where he actually places upon us, he cites a paragraph of the second amended complaint where we congratulate Armistead Mauck's efforts to, in essence, preserve and increase the value of the company through his participation in national and national organizations to uplift the company. He uses that against us to undermine our allegations and our work to show that the Cherries have actually undermined the success of the business. That's actually turning the entire standard on its head. So instead of viewing facts in favor of the plaintiff, the business court actually turned the standard against us. So I think, and that is at dismissal order paragraph 70, record page 460. We respectfully just think the business court got the standard just upside down. So Justice Berenger, I know that hit the particularity issue, and in regard to whether it's more of a breach of contract standard, I simply, as I stand here, don't recall that issue, and I'd be pleased to look again, and I don't know what I could do, but I regret that I'm unable to respond more fully at this time. I see I'm already pressed for time, and I'm not hit a remarkable minority of my argument. So pressing forward, I was to make sure I hit the stuff that I think is most important. Another error that the business court made is it seemed to imply a demand requirement on us in relation to our requirement or our complaint that we did not get a benefit for a tax distribution. We complained that we got a surprise, unprecedented $120,000 tax liability. In essence, Cherry Oil had never had a distribution before, and that was a matter of some dispute. Also, the tax liability was unforeseen, undisclosed. We asked for information, copies of the tax returns, and we also asked for a tax distribution. We were denied all of those, and the business court faulted us because we not made a prior demand. There is no law in North Carolina, no precedent in North Carolina requiring that. The only demand requirement we're aware of is in the derivative context. We also point out in our brief, and I would stress here, it doesn't, we think, make any sense to require that because it's impossible to foresee the need for a tax distribution if there's never been a tax distribution before. There's no precedent for it, so you wouldn't need to know as a matter of habit to demand a distribution. And further, they demonstrated their unwillingness to, in fact, give us information. So if we'd made the demand information that was sort of predicted the need for money, then they probably wouldn't have given it. So we believe placing that burden on us to make a demand for a hitherto unprecedented need for distribution, we believe that was unfair and error of the business court. So we stress that the central themes of this case turn on created burdens that have no precedent, a shifting of responsibilities from the plaintiffs, from the court to us in the terms of the demand requirement that doesn't make any logical sense in the context of the operations or the reasonable expectations of our client. And we ask that this court help us get a return to where these businesses had operated for the prior 20 or so years.
Counsel, you're well within your rebuttal time.
I noticed that on this clock, and I want to now yield my time as quickly as I can, and thank you, Your Honor.
Thank you, counsel. Hear from the appellee.
Thank you, Mr. Chief Justice, and may it please the court, Matthew Tilley here with Womble Bond Dickinson, along with my partner, Sam Hartzell, on behalf of the appellees. Both sides have in their briefs accused the other of rehashing the same arguments that were made before and dealt with in the business court in Judge Davis's lengthy opinions. Given the length of those opinions and the completeness of them, that may not be all that surprising. Judge Davis dealt with the complaint in a 40-page order on the motion to dismiss and another 36-page order for those claims that survived a summary judgment. Remarkably, plaintiffs say that Judge Davis erred every time and with respect to all 7 claims that he dealt with. One of the principal problems that we're dealing with here, and if you read the complaint or just the summaries of it, is it works as a series of lists of grievances. And they range all the way from a grievance that the Maucks had a reasonable expectation in the continued employment and management of the company to a complaint that Mr. Mauck, Olmsted, had his printer removed from his office and that is somehow part and parcel of a breach of fiduciary duty. The complaints, those grievances, like I said, move all the way from menial to and across subject matter. The complaint reasserts that same list of grievances with respect to every claim. The problem is that we're dealing with a number of conceptually different claims. And so each time, almost like a sieve, only a portion of that list is even potentially relevant. And the court did a good job of categorizing those claims and allegations and then dealing with them. But we have first of all, the Maucks' assertion in support of their dissolution claim that they had a reasonable expectation in the continued involvement in the management of the company and employment. We then have derivative claims that belong to each shareholder, and the court found.
Can I ask you about the standing claim?
Yes,
That's what
sir.
I'm most,
Yes, sir.
or the standing theory, which is what I'm interested in right now. You tell me what's wrong. I'm going to try to give like a really simplified version of a potential holding you might take from the business court, and tell me why this is not the holding. That a claim for dissolution is not justiciable if the statutory relief that you would receive in that dissolution would be something you're already entitled to as a matter of contract law.
Or that you've agreed to an alternative procedure to the dissolution claim, which is what Harris v. Testar says, which is the Court of Appeals case that the business court relied on. The business court treated that as redressability because essentially the statute was not going to redress the Maucks' claims, but instead that they had redress through the breach of contract claim or the shareholder agreement.
What I'm trying to figure out, not so much for this case, but for the future of our standing jurisprudence, is if that's sort of the box that belongs in.
And it might have mattered whether that was decided on 12b1 or 12b6 for your purposes on review of whether that results in a remand or affirmance on other alternative grounds had we been dealing with the initial complaint. The initial complaint did not mention the shareholder agreement. By the time we got to the second amended complaint, and so to decide it on 12b1, you had to go outside the pleadings because you had to look at the shareholder agreement. By the time we got to the second amended complaint asserts a claim for breach of the shareholder agreement. So it's incorporated by reference into the pleadings. You don't have to go to extraneous facts outside the pleadings in order to decide that. And so it's a perfectly valid alternative ground to say, look, that's not a 12b1 issue, that's a 12b6, properly characterized as a 12b6 issue, but still affirm it here because it's an issue and a question of law just the same as if it had been decided on 12b1. You don't have any questions as to what the proper facts are for the standard of review there, and that's what we would submit. The plaintiffs mischaracterize, I think, also what the court was doing there, and I think you and I just touched on it. They say that, well, there could be reasonable expectations outside the agreement that came from the course of dealing. The court credited that. The court, there's in paragraph 38 of the second amended complaint, the plaintiffs alleged that they had an expectation to be continually involved in the management of Cherry Oil. The court said that's fine, but Meiselman says what the problem with closed corporations is that they're essentially incorporated partnerships, and minority shareholders don't always have the ability to ask for things like put-call provisions that would allow them to sell their interest if they get stuck and are tagging along with the majority and lose those reasonable expectations. Well, if you have negotiated for that in advance and you have a put call provision in a shareholder agreement, there's no need to invoke MISA because instead you have an agreed upon procedure. And really the only difference in the procedure here, because once the court finds that dissolution may be necessary to protect the interest of the minority shareholder, the corporation has the ability to elect to buy the shares, essentially the same thing as the call, at fair market value upon such procedures as the court sets. There's no dictated set of procedures. Well, the parties here agreed to a set of procedures. They said, okay, the seller will either agree and stipulate, or if not, we'll agree to an appraiser, or if we can't agree to an appraiser and we can't get that far, we'll agree that the seller appoints one, the corporation appoints another, they appoint a third, and they'll go decide. But they agreed to a procedure that is possibly more efficient, but at least more predictable than submitting to the court dissolution procedures under the statutes. And the fact that they agreed to an alternative is part of what is anticipated in the Business Corporation Act when it allows shareholder agreements to supplant and alter the default rules for the dissolution. So
Let me just, I know I want to let you get on to the other stuff, but let me restate this again. You just, if I'm
yes, sir.
getting this wrong, let me know. But I hear you saying that potentially what we could do is say the operating, the contract, essentially, I'll call it the contract because this is what our law says, you can examine at the 12B6 stage where ordinarily you can't look at other things that are outside the four corners of the complaint. So the court can say, I know what this means as a matter of law because that's a question of law. And then look at the claim for dissolution and say, by statute, the relief that you would be entitled to here is something that is already governed by a contract, and what you get, and therefore you cannot get any relief other than this thing that's already here. And you have not stated a claim on which relief could be granted for dissolution, something like that. Is that?
I think that's exactly right. I mean, Harris v. Testar is a Court of Appeals case coming from summary judgment, but it essentially follows that logic and rubric, right? And so, I mean, the contract came in on the pleadings because it was referenced and relied upon in the pleadings. Its interpretation is a question of law. Whether that states a claim for judicial dissolution or the contractual remedy is also a question of law, and whether the contractual remedy supplants it. I would move on to the address to some regard the breach of fiduciary duty claims. And Justice Behringer, you asked if the court was saying essentially that many of those claims were supplanted by breach of contract. I think really what was happening is the court said essentially three things. One, it said, look, to the extent that this is a derivative claim and we're talking about damage to the shareholders, there's an allegation that Cherry Oil does well better than all of its competitors in the national, or most of its competitors in the national market by benchmark because it's been managed so well. That's a little bit inconsistent with the idea of harm, which would be necessary for breach of fiduciary duty. But in any event, there are individual breach of fiduciary duty claims that the Maucks assert because they're minority shareholders. Those are not the same as the derivative claims. Those are the claims that, well, they were ousted from the management or somehow ousted from, or somehow subject to oppressive treatment in the management of the company. Those go to the individual claims. Now let's look at those that are derivative, that truly belong to the allegations that truly belong to the shareholders. Is there any self-dealing? And one of the things that only looking at the motion to dismiss in the summary judgment order does a little bit of a disservice to Judge Davis is that he had also previously ruled on a motion to disqualify our firm because plaintiffs alleged that we could not represent both the company with respect to and its executive leadership with respect to the derivative claims. And Judge Davis did a very careful analysis to say, look, most courts look there to see whether there's serious misconduct and self-dealing. And if there's self-dealing, that may need separate representation. If not, the management and the company's interest may be aligned for the purposes of representation sufficient they could have the same firm. And he said, look, these allegations are not allegations of self-dealing in the usual sense. Usually that's a conflict of interest transaction. I did business with another company as a director or an officer, did business with another company I own. I didn't disclose that to someone in a lot of cases. And I've gotten a personal benefit from that transaction. That's self-dealing. That's breach of duty of loyalty if it's not fair to the company. But that's not what's alleged here. Their allegation of self-dealing is managing the company to their own political interest, in managing it to the benefit of putting Jason in as an executive. And if that were true, if that were self-dealing, every time you had a majority shareholder that had a favored executive, you would see a self-dealing claim. That's instead, and Judge Davis points to cases where selection of the executive is instead a duty of care claim. Is that person appropriately qualified to be doing the job? If there's no allegation of self-dealing, we don't fall out of the business judgment rule anymore. We're within the business judgment rule. The other allegations, such as extending credit to high-risk customers or not calling certain customers who were calling back in a timely manner, those are duty of care allegations. And if there's no self-dealing, they're covered by the business judgment rule, the presumption that the company presumption that the company acted in the best interest, and without anything else to knock them out, that's subject to dismissal on 12b-6. And so he had to sift through the allegations to say, look, these are the ones that are individual. These are the ones that are the contractual reasonable claims. These are the reasonable expectations, the Meiselman claims. Here are the derivative claims, and they're all duty of care claims. They're all covered by the business judgment rule, and there's no self-dealing, and then knock them out. So it's not a case of trying to knock out the claims without allowing proof. It's really trying to sift through and look at what the plaintiffs are actually alleging. The same thing happens with the constructive fraud cases. The two cases that we have, as you all know, constructive fraud requires breach of fiduciary duty plus a personal benefit. Well, if there's no self-dealing, there's really not that allegation. Barger versus McCoy and White versus Consolidated Planning both stand for the proposition that continued relationships between companies. So in Barger, there was an allegation of negligent misrepresentation against an accounting firm, and the alleged personal benefit to that company in making those representations was, well, you got to continue doing business with the company because you told us the information that management wanted to hear. And the court said, no, that continued just relationship or just fee for service, as White versus Consolidated Planning puts it, is not a personal benefit sufficient to result in constructive or wrongful benefit sufficient to support constructive fraud. Instead, you'd have to show some other sort of personalized self-dealing or benefit. That was not present here, and so constructive fraud fell away too. Once again, they try to say that trying to favor Jason, Jay's son, within the company and within the promotion of the company and its management was somehow a benefit to Jay and Ann. It might be in the political sense of that, but once again, that's a proposed rule that would swallow the constructive fraud distinction, because if every time you had a majority shareholder and they favored one person over another because they were their ally, you would see a constructive fraud claim in addition to other claims. Mr. Tippett mentioned with respect to the individual breach of fiduciary duty claims, the issuance of a dividend. And I'll deal with the individual breach of fiduciary duty claims this way. First of all, I'd like to point out that the court allowed those to survive motion to dismiss. They were decided on summary judgment. The court found the allegations sufficient to say that, look, there's some allegation that there is a breach of the fiduciary duties that are owed minority shareholders or some oppressive conduct, but then ultimately found that there was no evidence of them when it came time for summary judgment. It's important to understand what those duties are. The fiduciary, the case law that the court cited, Thomas McMahon, which is a business court case, which is what it used for the standard and all the parties agree, states the proper standard, says that a majority shareholder within a closely held corporation owes the minority shareholders the duty to provide the largest possible payout or benefit to come from the corporation's property, to protect the interest of the minority, and to pay out the proceeds and profits of the company. Plaintiffs conflate that with their reasonable expectation argument under Meiselman. They had a reasonable expectation of continued employment and management of the company. Meiselman does not treat those types of reasonable expectations, though, as questions of fiduciary duty. Meiselman first held that, look, because closely held corporations are essentially incorporated partnerships, and there's not always an opportunity for the minority to negotiate things like a put-call provision, we have to protect their reasonable expectations and look to what those were going into the deal. It then separately dealt with a breach of fiduciary duty claim for usurpation of corporate opportunity and stated that claim in terms of fiduciary duty. Those are separate claims. The court noted that and said, look, to the extent the Maucks expected to be continued to be involved in the management, that's their reasonable expectation claim. That's the part that's covered by the put-call provision that allows them to get out if that ever breaks down. As to the minority duties to shareholders, they're those three things that I listed. Plaintiffs zero in on the fact that there was not a dividend. And the court said, well, the court looked at that and said, well, at this stage, there was never a demand for that. And so, seems to be no evidence on that on summary judgment. Let it go.
And Counselor, I would like for you to address the argument that I understood that on this phantom income of such a large amount that created an obligation for them to pay taxes for which they had no cash from the company to pay. I understand that that's either, in their view, a fiduciary obligation breach or at least a breach of reasonable expectation. How do you answer that when it was unanticipated because it evidently never happened before?
I think that it's important that what they cite every time in the cases they cite, which are Gaines, Johnston, Flynn, and Cumberland, are all 12B6 cases. They say, look, saying that the majority didn't authorize a distribution or a dividend in certain circumstances may be enough to allege a breach of fiduciary duty claim. But by the time this case got to summary judgment, all the evidence that there was that there was a tax liability in 2023, K1s, of $120,000 to the Maucks, obviously more to Jay and Ann, who held 2/3, and there wasn't a distribution. You would need to show more, and in fact, even to the cases they cite, Gaines, Johnston, and Flynn, there was more alleged to show that was a breach, oppressive conduct to the minority shareholders, and a breach of fiduciary duty. For instance, in Johnston, there was a showing that there was a history of distributions, that more money had come into the company that year than ever before, and that the majority shareholders simply didn't allow a dividend because they wanted to trick, if you would, the minority shareholder into making a demand, which triggered a put call under the governing documents for that corporation. So they wanted to basically force him to trigger a put call. In Flynn, the allegation was that the management had given itself excessive compensation in lieu of making a dividend so that they could take it and not distribute it to the minority shareholder. In Cumberland, there was a refusal to make distributions that had been approved by the board of directors, but the majority shareholder was in sufficient control that they just refused to do it. Those are over and above. There was a $120,000 tax liability and there didn't happen to be a distribution that year. You would need to show more at summary judgment to establish a breach of fiduciary duty claim. Frankly, there also was not anything in the reasonable to show that there was a reasonable expectation of that based on course of dealing. Justice Berringer, did that address what you?
Yes, it did.
Finally, there was, and as I mentioned, the second amended complaint added a claim for breach of the shareholder agreement. And this one was a bit confusing. And the court went through the chronology and said, look, and the shareholder agreement, and by alleging that the company did not close within 60 days as required by the shareholder agreement on the purchase of the Mauck shares. And the court looked through the chronology and used the term, and I admit it's there, on balance, the Maucks are the ones that caused that.
And you've anticipated my next question.
I do not think that that was weighing of the evidence at summary judgment. If you look carefully at the chronology and what happened, there and some of this is complicated by the plaintiff's own claims. They were arguing three things at once. First, the call was initially authorized by the board of directors at 16 June 2021. They said that wasn't properly noticed because it was not 10 days notice, and it gets into mailbox rule issues. The court said no to that ultimately, but that was their first allegation. Second, they said, and so the call was done on 16 June. The company offered to buy the shares. So the first step, let's agree on a price at something that they thought the company thought was over and above FMV because it didn't include discounts for control or lack of control or lack of marketability. Plaintiffs rejected that, and they said you didn't do a valid call at all because you didn't notice it properly. Plaintiffs also didn't go through the next step, which would have been for them to have appointed, as the selling shareholders, an appraiser. So the process stopped and did not restart again until the company again brought it up a year later, said, do you want to voluntarily restart this process, in a letter between counsel? Plaintiff said no. The Cherry restarted the process through resolutions reaffirming the call on 6 October 2022. That time the plaintiff did go along with it for a while. The plaintiffs did go along with it for a while. They appointed an appraiser. Defendants appointed an appraiser on November 30th. There's supposed to be 15 days for those two to pick the third. But the close date would have been December 5th. So December 5th versus December 15th, there was a letter between counsel. Do you want to extend that so that the process can go on? And I've marked it. It's plaintiff's counsel's letter back on December 8th, 2022 at DocX 410. He writes back, the Maucks believe that the process for the call should move forward as required under the 1998 shareholder agreement. That cannot happen for reasons cited in the final paragraph of this letter because, as stated, the defendants in our motion to dismiss, the appraisals must take place before the option can even be called. So the call has to happen after the appraisal first. And they say that it's because the appraisal is a condition precedent, we're not under the shareholder agreement again. And then refused, and then suggest that maybe we mediate, maybe we go to discuss a global agreement. So once again, plaintiff definitively stopped the process by the legal position that they took. That's not an on balance weighing of the evidence or credibility. That's
But didn't the business court say before it said on balance? I recall something along the lines of that neither party was rushing to get this thing closed. I'm paraphrasing, but something along that. But then he says, but on balance.
But on balance. Possibly the way to look at that is to say, look, it's either prior material breach because the plaintiff didn't go along with the process, or estoppel because the plaintiff took a legal position that was inconsistent with the process being able to move forward and that stalled it. And that, so if you look, while neither party may have moved it along, plaintiff stopped it twice. And if it stopped because of plaintiff's actions, a better legal term may have been plaintiff is stopped from now asserting that there's been a breach because it didn't move forward in a timely fashion. And so on balance may not be the best choice of words. It may not be the most technical legal argument, but it's very clear if you look at this record that plaintiff took a legal position that it could not move forward, and that stopped the call process. Because of that, there is no breach. And so, again, it would have been remarkable to think that in dismissing and in roughly 76 pages of careful analysis, the business court got it wrong every time, or didn't understand the proper procedural requirements of summary judgment and motion to dismiss, which we're all familiar with. We contend that the business court got it right, and that quibbling with some word choices, particularly rhetorical ones that are transitioning between paragraphs, does not transform somehow a careful legal analysis that follows well-established law into error.
If I might point your attention to one point that you just made as far as this factual point, that the the plaintiffs stopped the process with an argument that there should have been an appraisal before the call, and the business court said the better reading is the other way. What if we decide that the reading is better the other way? Would that undermine your argument? Because one of the things you could think about, not in this case, because evidently this business had a good cash position and could most likely pay any call, but without having an appraisal, how would they know if the company could afford to make the distribution that they would have to make under the provision of the put-call provision?
You know, it's fairly standard to see put-call provisions that say call and then appraise, and that resolve disagreements about fair market value of the stock and shares, which is really a difficult thing in a closely valued corporation, to follow the call resolution. So that's a fairly standard procedure in most shareholder agreements. It seems, I think that it is a question of law for you whether one follows the other. It may change the analysis if you were to think that it is actually flipped. But I'd note
But
that,
since it's ordinarily or oftentimes spelled out in an agreement, and the fact that it's not spelled out in an agreement, is your position is that the law has to fill in the blanks, or do we presume the opposite since it's not filled out that way?
I don't know that there's any basis within the contract to presume the opposite. I mean, to get to their position, you'd have to say that the appraisal was a condition precedent to the call. And normally the law is that you have to call out condition precedents pretty explicitly in a contract for them to be conditions precedent. This is not one of those circumstances where this contract does that. It talks about a call, and then it says the call shall be at the price in 6. Go to 6. So that, I think Judge Davis's view is that, okay, well, if you have a call and then you go to 6 and it refers you there, that would make sense for that to be the temporal sequencing. But I would note that essentially the equivalent is the same under the judicial dissolution standard. So if you look at 55-40-30 and 31, the court first makes a determination that a dissolution is necessary. It then proceeds to appraise and find out what everyone's interests are. And in that process, the company has an ability to elect to try to buy the shares instead. But the judicial procedures are very flexible there, but they follow a determination of the call first, if you will. So it's not even different than the statutory sequence to have the call resolution come first and then the appraisal. Once again, we believe that Judge Davis got it right. We believe the opinions are well-reasoned and rely on well-established precedent. If there are no further questions, I thank you for your time.
Thank you, counsel. Rebuttal.
Briefly, just a few clarifications. They seem to rely on Harris v. Testar. A very important issue to call your attention to is in Harris v. Testar, there was no dispute about reasonable expectations because in that case, the parties agreed that the shareholder agreement reflected the reasonable expectations of the shareholder. It was stipulated in discovery. It was on the record on appeal. That is not the case in this matter. Second,
because your clients say there was also more control. They thought they were entitled to more control. Is that the additional expectation?
Correct. And there was just a career's worth of other activities. The Mauck's involvement was different. And during a deposition in Testar, the plaintiffs basically acknowledged, yeah, the document reflects our expectations. It's not the case here, so that precedent is not particularly helpful in this case, we contend. Second, I miscalled out Pinby when I meant Pinley v. Pinley. I just want to make sure that your notes might accurately reflect that. Second, it's remarkable that when they're talking about the personal benefit, they cite the business court's decision in this case in support of the business court's subsequent decision in this case as guiding precedent. I don't think you should find it compelling. It remains the case that there is no support for the argument that an irresponsible decision to promote one's legacy within the company cannot be an improper personal benefit. Whether or not the choice to choose an irresponsible successor can be a basis for a claim, and to conclude other as a matter of precedent in North Carolina, I think would be a bold call. And their argument that this judge's decision on a different order in this case, I think, is not something that you should rely on. Next, the argument about the timing of when this deal should have closed is beyond question that it couldn't have got done within 60 days. It's impossible. How that shakes out in this court's decision, I'm not sure, but it's inconceivable it could have gotten done within 60 days. And their citing of my letter of pointing that out does not distinguish the fact that my client's only responsibility in the appraisal process was to appoint an appraiser, whether or not.
Thank you, counsel. Leave your
Thank
time's
you very much
expired.
for your consideration.
All rise.